Hello, and welcome to Hospice Insights, the Law and Beyond, where we connect you to what matters in the ever-changing world of hospice and palliative care. Well, hello, Joe. Hello, Zaina. Welcome to the podcast. I appreciate you making time. Joe, you're a returning guest, although there's been quite a pause between your last appearance on the podcast and now. Isn't that right?
Well, that's right. Thanks for having me here, Brian. That just goes to show how long you've been doing the podcast and how long it's been a great success.
Yeah, well, thanks, Joe. And you are, as our audience will get to know, you are the person we turn to when we get into federal court. And it's not a place that you want to volunteer to go to, but if you need to go to federal court, and hospices have had a need to do that increasingly over the years, you're the guy, and you're the one we turn to, and we've had a lot of success with you. So welcome back. And Zaina, you're more of a regular to the podcast, but you also work on all things hospice, including these federal court cases. So I'm glad you're able to be here.
Thank you for having me, Brian.
Sure. So what we're going to talk about today is maybe a bright spot in this landscape of CMS trying to crush fraud. We can all agree, I think, that crushing fraud sounds like a very noble and worthwhile goal. I think, in my experience, Zaina, you and I representing hospices all over the country on the front lines of enforcement issues, what we've seen is they're certainly crushing fraud, but they also seem to be stepping on some providers that are high-quality providers. It's the old casting a wide net. And inevitably, some of the good guys get caught up in it. So definitely fraudsters are getting caught, but Zaina, you and I are helping the good guys continue to be able to serve these vulnerable patients. And that's been a real challenge. And I think over the past 6 months, definitely, Zaina, the kind of increased enforcement that you've seen, I know you've been on the hospice team for a number of years, but what's your perspective on like the last 6-8 months of hospice enforcement efforts?
Well, the government's really keeping us busy, Brian. I think we've referred to it as a sledgehammer approach as opposed to the scalpel approach that we think is warranted to root out these fraudsters. But we have certainly seen an increase in audit activity, audits of all kinds, and then also an escalation in some of the consequences that are being imposed based on quote unquote poor audit performance. So things like payment suspensions, revocations of billing privileges, huge extrapolated overpayments, and the like.
Yeah, that's for sure. And a lot of pressure being put on hospices. And really one of the bread and butter areas of our hospice team is our audits. And so what I mean by that is you have all sorts of CMS contractors auditing hospices, looking at their medical records and determining whether those medical records support a terminal prognosis, whether all the documentation that's required dots all the I's, crosses all the T's, like election statements. And so, Zaina, I don't think a week goes by when somebody on our team isn't doing an ALJ hearing or other kind of administrative appeal where we have our expert physicians lined up trying to advocate and persuade an administrative law judge that a medical record, in fact, does support a terminal illness, even though CMS contractors would think otherwise. And that really brings us to the heart of this episode, where over the past few years, we've seen a number of ALJs get more aggressive in taking on the role of, in our view, we think they may be playing doctor a little bit, where they're reviewing a medical record and coming to their own layperson conclusion about terminality, even when it is directly contrary to physician testimony, and it's undisputed physician testimony. So that's one area where we're going to federal court. We have gone in a number of cases. Go to federal court to say the ALJs are overstepping the boundaries of what they're authorized or competent to do. And another area is what is called a limitation of liability aspect of the Medicare hospice benefit. And what that means is, in essence, Congress enacted a law that says that if a hospice had a reasonable belief that it would get paid for a service it provided based upon an interpretation of a medical record that to the hospice supported a terminal condition, that the hospice should get paid for that, even if an ALJ might disagree on whether the record actually supports terminality. As long as the hospice was reasonable in its interpretation of the record that's supporting that, then it ought to get paid. And so that's another thing that we've appealed to federal courts. And Joe, that's what brings us to a really important decision that came out recently from the Sixth Circuit Court of Appeals that, in our view, was a very positive development for hospices on that limitation of liability issue. So, Joe, I want to kind of invite you into this and set the legal stage, if you could, like how the appeal gets to the Court of Appeals. And then after that, let's talk a bit about the issue and the decision from the federal court. So set the stage for us, Joe.
Absolutely. So as listeners may have different levels of familiarity with, when you're at the ALJ, you've already dealt with a number of levels of contractor review. Then you have a trial-like proceeding before an ALJ who may hear some evidence, get some documents, and then make a decision about whether or not the medical evidence supports a terminal prognosis. And as Brian mentioned, even if the ALJ says, no, this doesn't support a terminal prognosis, there's still a question of this limitation of liability, or sometimes called safe harbor provision under the Medicare statute. And I'll get back to that. If a hospice or any other healthcare provider that's going through the Medicare appeals process disagrees with an ALJ decision, they then have two more paths. Number one, they initially have to go to the Medicare Appeals Council, and if the council either doesn't act or affirms the ALJ's decision, then you can go to federal district court. In this particular case, we went to the U.S. District Court for the Northern District of Ohio because that's where our hospice client was located. And then a federal judge with life tenure, reviews the ALJ's decision. But there's not a new trial. He's just looking to determine whether the ALJ applied the correct law and had some evidence to support his or her decision. For this case, we lost at the district court. The district court agreed with the ALJ on all of the relevant decisions that the ALJ made.
But that's not the end of the story. This has a happy ending. So
that is that is far from the end of the story. So federal district courts like that, they make decisions that just decide the case. But then there's another level of federal court above that, one level below the U.S. Supreme Court. It's the U.S. Court of Appeals for the Sixth Circuit. And these circuits are also geographical. The Sixth Circuit hears appeals from all courts from all federal courts in Michigan, Ohio, Kentucky, and Tennessee. And so once we go up there, we re-argue the case. And again, there's no trial, but there is another round of legal briefing and oral argument. And they're also doing the same kind of review of the ALJs. And this time, two things. So first of all, when a federal court of appeals makes a decision, not only does that matter for the particular case, but that also means that any district court in those states has to follow whatever the circuit court says going forward. So when the appeals court says something, it's very important. And we were very fortunate to win on the limitation of liability issue in this case.
Joe, Joe,
go ahead, Brian.
You mentioned the federal courts in those four states. They're bound by this. What about federal district courts in other states? How would they view a decision from the Sixth Circuit Court of Appeals, like a case in Texas or California or Maine or something? How would they perceive that kind of decision?
So that's actually a super important question for this case in particular, because when you have a federal court in a different state, they're not bound to follow what the Sixth Circuit does. They have their own circuits that they have to follow. But if their circuit has not decided the relevant issue, then they often look to what a different circuit, a court of appeals, has done as highly persuasive and informative. And on the question of limitation of liability under Medicare for hospice, this Sixth Circuit case that we're talking about today is the first court anywhere in the country at that court of appeals level to make this determination. So we think in our industry it's going to be hugely persuasive for all other pending federal district court cases and even ALJ cases that are currently pending.
Yeah, and so ALJs are bound. I guess ALJs hearing cases relating to the four states, they're bound by this.
Yes, they have to follow circuit precedent as well.
All right. Well, great. Take us to the issues then. Kind of give us the rundown on what the court decided.
Yeah, absolutely. If you want to read more of the case, the name of the case is In Home Health v. Kennedy. It's number 253542. The key issue here is that limitation of liability or safe harbor provision of the Medicare Act. So what happens when you get all the way to the ALJ and the ALJ says, actually, I don't think there was coverage here. I don't think this patient was terminally ill. Even when that's the case, Medicare still sometimes has to pay for those services in regardless. And that happens when a provider acts in good faith and reasonably, even if wrongly, in concluding that a patient is terminally ill. So the Sixth Circuit went through the statutory language, which, Brian, you did a beautiful job of making it sound clear, but when you actually read it on the page, it's anything but. And that's what's tripped up some ALJs in the past. It's tripped up some federal district courts in the past. But I think the Sixth Circuit does a great job of really making it clear what an ALJ has to do going forward.
Yeah, you go through the language. It's like double negatives, and it is a twist and turn that you have to navigate through.
Exactly. So the key phrases here from the Sixth Circuit, it says an ALJ must consider whether a provider could reasonably have interpreted the relevant notices or local standards of practice as covering each denied claim. And if a provider reasonably, albeit incorrectly, interpreted Medicare's notices and standards as covering a patient's claim of terminal illness, then the safe harbor saves them from liability, meaning they get reimbursed for that patient's care. Now, what that means for hospice is incredibly important. There might be other circumstances where there's not really daylight between actual coverage and reasonably interpreting the standards for coverage. For example, if Medicare has made it clear and is a guidance document that you can't prescribe a certain medication for a certain condition, or you can't use a particular type of medical device to treat some ailment, then that makes it pretty clear, and it would be totally unreasonable to say that I just made a mistake. But when you're dealing with local coverage determinations that are often the case in hospice, and there are no black and white answers in them. Sometimes it's multi-factor tests or things that are open for interpretation that nurses and doctors might reasonably disagree on. That reasonableness part of this matters a lot because our physicians or our clients' physicians might reasonably at the time think that this patient is in fact terminally ill. And then an ALJ might disagree with that and also be reasonable in disagreeing with that several years later. But at the end of the day, the safe harbor provision says as long as both sides were reasonable, the provider still gets paid. And that's what this decision makes crystal clear. And hopefully this decision will not only apply in those 4 states where the Sixth Circuit is, but also across many other states and in the entire country.
Yeah, and Joe, I think to kind of dig into your description of, cases where there may be some daylight between whether there's coverage and whether it should be paid. An example I think of, and I'm making this up. I'm not a doctor, but I think it's a good way to illustrate it. Let's say there's a local coverage determination that one of the MACs has put out that says we will only cover this surgery or this medication for your heart if you have an ejection fraction of less than 20%. Well, okay, you measure the ejection fraction, you either do or you don't, and therefore either the medication or surgery is covered or it is not. It can be somewhat black and white. In the hospice space, there are local coverage determinations, but they're far from black and white. And I think they're intentionally open-ended to provide that it's a recognition of the inexact nature of prognostication. And I think what was helpful in this case is the court recognized the open-ended nature or the non-mandatory, the gray area of prognostication, which is something that I don't think ALJs or other contractor decision makers have recognized to this point. So I think along those lines, what we've seen in a lot of these decisions is an ALJ, the Quick, the MAC, they will say, well, you don't get the limitation of liability because there's an LCD that's published and you should have known from looking at the LCD. Does the Sixth Circuit allow that kind of reasoning to be made anymore, or does it shut the door on that?
The Sixth Circuit shuts the door on that. So that is exactly the reasoning that the ALJ in this Sixth Circuit case had used, and the Sixth Circuit said that's not enough. You have to. So the Sixth Circuit actually sent this case back to the ALJ to try again on the question of limitation of liability, and it said you have to analyze not only whether the provider literally had notice of the LCD, because of course they did. You have to analyze whether what they said, applying that to the particular patients in the case, was a reasonable thing for a doctor to do at the time they did it.
All right. Well, great. And Zaina, let me involve you because Joe is our federal court go-to person. But Zaina, you lead our efforts on all of the audit activity that leads up to federal court. You're also involved in federal court on the briefing side. But regarding this denial reason that you're not entitled to the limitation of liability because the regulations and the local coverage determinations put the hospice on notice that these claims wouldn't be covered. How prevalent is that as a reason not to allow a limitation of liability for a particular hospice?
Brian, all of the underlying decisions that we get from these CMS contractors usually include a sentence or two that just wholesale dismisses the application of Section 1879, the limitation of liability section. And they do typically only give the rationale that the provider had notice because these guidelines are published. And so since I very first joined the team back in 2020, we have always argued in our appeal documents up through the ALJ phase that it would be impossible to determine based on these generic guidelines and rules and regulations, including the LCDs, whether each individual patient with unique clinical circumstances would not have their care covered and paid by Medicare. So that's a routine argument that we raise. And up to this point, it really didn't have any teeth. It was just dismissed. And now the favorable decisions that we've gotten in federal district courts and also at the Sixth Circuit, like Joe just discussed, really take the wind out of the contractors' sails, because they say that it's not enough to just give a blanket statement that the provider had constructive notice. There has to be a case-by-case determination of whether the provider was reasonable in providing that care and billing for those claims.
Yeah, I think the practical effect of this for those hospices that have gone through the appeal process and you're sitting with an ALJ decision, ALJs, they always address this limitation of liability. It's sometimes known as the 1879 argument or consideration because that's the section of the Social Security Act. But if you take a look at your ALJ decision, and if the ALJ said the hospice was on notice that these claims would not get paid because LCDs are published and the regulations are published, Joe, that's what you have kind of interpreting the Sixth Circuit decision as saying that is insufficient. That is something that can be reversed, and the ALJ needs to try again on that. Is that what I'm hearing?
That's right.
Great. So I think, Zaina, what you said about this is a standard decision in every ALJ decision we have received. It can really open up opportunities to try to get another go at some of those decisions. Now, it remains to be seen. In this case, Joe, it was remanded, so the ALJ is going to get another attempt at this in applying the correct interpretation. Is that right?
Yep, that's right.
Okay. So it remains to be seen whether the ALJ is going to be able to come up with another decision that results in denial. But at least there's this opportunity to take the case to an appeal and try to get another stab at a victory in some of these cases. And now this is not the only case we've worked on. Dana, you and I have been involved in cases at the district court level, so a level short of the Court of Appeals. We recently had a case out of the Northern District of Indiana. Why don't you describe the central holdings of that case and how it relates to hospices?
Sure. So just taking a step back for a second, Brian, and providing the context again here. In order for a decision, an ALJ's decision to withstand scrutiny upon judicial review, the decision has to be supported by substantial evidence, and it also has to apply the correct law. We've already talked a little bit about the holding with regard to the limitation of liability provision there. But just to put a finer point on it, the court in Indiana agreed with our longstanding argument that simply stating a provider had notice based on the publication of rules and regulations is not enough to establish that that provider is not entitled to payment for the care that it provided. And so the ALJ, or the judge in that case rather, said the ALJ's blanket inference of constructive notice was really an error of law, and that's something that on remand, the ALJ is going to have to cure in their decision.
And so it kind of anticipated the Sixth Circuit decision, but the Sixth Circuit being a higher court, that has a lot more persuasive power to it. But it's not just the Sixth Circuit. We have a case out of Indiana now, which is outside the Sixth Circuit, but at a lower court level, that essentially shares the Sixth Circuit's view.
Absolutely.
And what else about that case? Was there any other aspect of that case that was noteworthy?
Yes, we won on another very important issue regarding the substantial evidence piece. So in that case, the court also found that the decision was flawed because the ALJ did not show that there were substantial evidence supporting his conclusion. And they cited to two examples of how the decision wasn't supported by substantial evidence. The first was that the ALJ conclusively dismissed certain symptoms as insignificant to support a terminal prognosis without providing a sufficient basis for that conclusion. And then the decision was also flawed because the ALJ did not explain why he ignored or disregarded the hospice physician's expert testimony provided during the hearing. And so the court went on to say that while an ALJ is allowed to dismiss an expert's opinion, they have to give legitimate reasons for doing so, and simply paraphrasing portions of the expert's testimony without really engaging with it or providing any reasoning or rationale of why those conclusions are insufficient renders the decision unsupported by substantial evidence.
And this is essentially the argument we've been making about ALJ's improperly playing doctor. And I think, Dana, you and I see this in ALJ decision after decision after decision. They'll list a number of clinical data points. They might summarize the testimony of the hospice's expert, but then in a very short fashion, they'll say, I don't think that information was sufficient. Essentially the patient wasn't sick enough to be terminal, without explaining why they think that or based on what. It's very frustrating to have an administrative law judge who is an attorney, former attorney, to just disagree with a physician, often board certified physician, board certified in hospice, without explaining where did that hospice physician go wrong. So we're kind of left scratching our heads a lot. So I remember when this decision came down, it was refreshing to see a court really put it to the ALJ. You can't just say you disagree. You got to say why you disagree so that the court can tell if you disagreed on appropriate grounds. If you disagree with the physician because you don't like the way they parted their hair, well, that's a problem. And if you don't agree because you don't think it was sufficient, well, why wasn't it sufficient? There's so many variables in prognostication that it's hard to just say it's not sufficient without that explanation. So
right. And Brand, one of the ways that a lot of the underlying case law characterizes the substantial evidence piece is they refer to a logical bridge. An ALJ isn't allowed to just list out clinical data points and then conclude that the patient wasn't terminally ill. They have to provide a logical bridge to show how they got from the information that they're citing, including any evidence from expert testimony, to their ultimate conclusion that the services were not reasonable and necessary, or that the patient did not have a terminal prognosis. And where that logical bridge is missing, that renders the decision flawed, and in this case at least warranted a remand back to the ALJ for further consideration and explanation.
Yeah, so kind of the practical takeaway from this is, again, if you've been before the ALJ, you have a decision and you don't see the kinds of explanations supporting the ALJ's rationale, you may have a potential appealable issue to go to federal court and have that administrative law judge take a new crack at it. Or what you're able to do is just ask the federal court to reverse the ALJ. We've been able to obtain that in some cases, but at least you get another kick at it with some of these flaws in ALJ decisions. And I just want to wrap up this podcast with a couple other decisions that kind of echo the same themes. One of them echoes the same themes here. One is out of Florida, where hospice is big business down there. And we, in the past couple of months, we got a decision from a Florida district court, so not a court of appeals, it's the trial level court, that looked at the Medicare regulations themselves. So not the limitation of liability, which is part of the Social Security Act, but it looked at the Medicare hospice regulation. And Joe described kind of how the limitation of liability standard identified by the Sixth Circuit is you need to have a reasonable interpretation of the medical record, not the definitive interpretation. Well, this court in Florida agreed with our argument that even outside the limitation of liability statute, a similar standard applies just under the regular Medicare hospice regulation, that also requires a reasonableness test as opposed to a definitive test that requires proof of a terminal illness. And that court criticized the ALJ for her repeated use or phrasing of, well, the hospice didn't establish terminality or didn't kind of demonstrate or prove it. And the judge says that's too high a standard. The standard is, was the hospice reasonable? So kind of taking it from another angle, we have a court in Florida now in another area of the law, tilting the scales a little bit more in the favor of the hospices than they were before that decision. Now, that just applies to that particular case, but we have a few other cases that have reached similar results, and so we hope to keep the momentum up with some other cases we have pending. One final case that's completely unrelated to any of these issues, but it was a win for a hospice, so I want to talk about it. We represented a hospice that, according to the administrative law judge, it failed to file an appeal on time. You usually have 60 days to file an appeal. Well, this administrative law judge said the hospice was too late. Now, the problem with that decision was that the hospice never got the decisions that it was supposed to have appealed. Well, how can it appeal a decision it's never received? And the ALJ said, well, you should have gone out and gotten the decisions or made some effort to obtain them. We appealed that to federal court. This is back in Ohio. And the judge agreed with us that the deadline is triggered, the appeal deadline is triggered not by when you could have received a decision, but when you actually received them. And so after several weeks of effort, we ultimately got the QUIC to fax us the decisions it issued. But I think these were decisions dated October 3rd. They didn't fax them to us until January. So quite a time lag, but the federal court nonetheless said, your deadline started in January, not in October. So that was another success. Several hundreds of thousands of dollars are now back in play for this hospice to go through the appeal and try to win. So overall, we're seeing some good news on the federal court level, which is very welcome in light of all the crushing fraud efforts that are out there. So Joe and Zaina, any kind of parting words based upon this? I think this is a happier podcast than some of the ones that are more issuing warnings and lookouts for things to do.
Nothing further from me, Brian. Thanks for having me on.
Yeah, happy to do it. Zaina, what's your words of wisdom for our clients?
My words of wisdom. Well, just a parting thought is it has been so vindicating to see these judges at all levels really agree with what we've been saying all along. And that is, ALJs, you're not allowed to just deny claims for no reason. You have to provide an explanation. You can't just ignore the Social Security Act because of a rule being published. You can't just ignore expert physician testimony because you are putting yourself up against a physician with absolutely no basis. And so it's been really vindicating, and I'm happy to see that these hospices are getting the results that they deserve, and hopefully they will be helpful for our other clients who are similarly situated.
Great. Well, Joe, thanks so much for being a part of this. We're not going to wait 5 years before you're on the next time. So we'll get you on here. And Zaina, thank you. And thank you both for fighting these battles on behalf of hospices. Now more than ever, they need help wherever they can get it. And I think these cases really are going to prove to be a difference maker in a lot of these. So thank you so much. And thank you, everybody, for listening. Take care. That's it for today's episode of Hospice Insights, The Law and Beyond. Thank you for joining the conversation. To subscribe to our podcast, visit our website at hushblackwell.com or sign up wherever you get your podcasts. Until next time, take care.